Oh, the Supreme Court. What a disaster. Boy, have you guys outlived your usefulness and just expanded the scope of your powers, or your perceived powers, and what you're allowed to get away with. And this one right here, of course, it has voting processes, it has election integrity in the name of the lawsuit, and you guys are just going to go ahead and kick that to the curb like the little red-headed stepchild or unaccompanied minor that crosses the southern border. Supreme Court rejects another election lawsuit targeting California's voting process. This one's a little bit different, okay? I don't think that this is in reference to the 2020 election, but it looks to clarify, and it kind of tangentially addresses a problem that I've brought up a few different times about California, how SoCal and NorCal look nothing like each other, how the little population hubs are as blue as sapphires, and yet the rest of the state up north, with the exception of San Francisco, obviously, would be much better suited in the greater Idaho project than it would be with the continued degradation of the rest of California. So that's what this one was looking to address. It was more or less just kind of a backdoor way of trying to get into a state electoral college, and doing something that radical would require some help. I don't know if the best way to go about that is through the Supreme Court, so I can understand why they kicked it down, but at the same time, somebody's got to hear these people's pleas. And it's definitely not any of the elected officials in California, because either you have Maxine Waters, Nancy Pelosi, Dianne Feinstein for the Democrats, or on the other side you have such weak-kneed Californians like Kevin McCarthy. Okay, Devin Nunes is a complete and utter aberration, but outside of that, they're fucking few and far between there. But let's see this case. I find it interesting. The Supreme Court rejected a case that challenged California's electoral system process by claiming that the state's so-called winner-take-all system dilutes their votes. The lawsuit was filed by comedian Paul Rodriguez. I feel like I should know that name. I just don't know who that is. At least by the name. It's fairly generic. Rocky Chavez, League of United Latin American Citizens, and California League of United Latin American Citizens. That sounds as redundant as it reads. And it has asked the Supreme Court to look into whether the aforementioned winner-take-all approach to selecting presidential electors was constitutional. Attorneys for Chavez and Rodriguez, who are both reportedly Republicans, I would imagine, based on this lawsuit, California's system results in the appointment of members of only one political party to the nation's largest electoral college delegation. Well, don't worry. It's shrinking, okay? Because for the next election cycle, they're going to have one fewer electoral college vote. But still, I understand. Chavez previously served in the California State Assembly and ran during the 2018 midterm election in California's 49th congressional district. Wonder who he ran up against. Oof, that poor prick didn't really fare all that well. And it's kind of a brand new district. It's only been around since the early 90s, but our friend Rocky here, he kind of finished with only a 7.5% of the vote in the initial runoff, and then, yeah, Diane Harkey kind of got fucking smashed by Mike Levin. But it wasn't always the case. They were coming off the back of Darrell Issa, who was kind of there for a while, so it kind of seems like a swing district. It's a little bit weird considering it encompasses a lot of San Diego, Orange County, and is right on the border. So, hey, I don't know, seems like someplace I could probably flip back if Mike Levin just, it has a misstep or 20. And San Diego is one of those weird larger cities in California that also has a Republican mayor, so I don't fucking know. But back to the story at hand. Remember, this is about the winner-take-all system in California and how, a couple of different cities control the voting destiny of the rest of the state. They stipulated that such a process is not within the Constitution and is instead a partisan invention by the states that has become the default for the nation, according to their lawsuit, further asserting that it severs the connection between voters and presidential candidates. Yeah, because the Electoral College was meant to circumvent something like this, the tyranny of the majority in the little cities, just having little cities across the 13 colonies out there control the elected government. But could they have foreseen something like, I don't know, Illinois from happening, where you have, what is it, like 80% of the population base in the Chicago area, and then the rest of the state, I keep wanting to say province, the rest of the state is not represented whatsoever. New York's the exact same way. Like, it's not specific, but one of the most extreme cases is in California, but it's something that's going to have to get addressed sooner rather than later, but I'd imagine it'll probably take for a Democrat to run afoul of the system in order for any real change to happen. But let's see the decision. But on Monday, the Supreme Court declined to hear the lawsuit in an unsigned order. Oh, okay, so they ain't going to fucking look at it whatsoever. The court didn't provide an explanation in denying Sartori. Lawyers for the Democratic governor, Gavin Newsom, the defendant in the suit, pushed back against the suit, claiming there is no cause for concern. California does not treat any voter group or voters differently from any other to prevent anyone from casting a vote. Yeah, if that's what they were suing on, listen, I'm very sympathetic to their cause, but maybe their lawsuit wasn't structured enough rightly address this concern. So that could very well be a decent response to this, because nobody's being robbed of their vote that we're allowed to prove. It just once again highlights the problem with a straight democracy. One vote per one person. Electoral College for every state now. While the winner-take-all system of awarding presidential electors certainly raises the stakes of victory, it does not interfere with petitioners' ability to associate freely with the political party of their choice or otherwise deprive them of an equal opportunity to win votes, Newsom attorneys wrote. The decision Monday suggests that Supreme Court justices have little appetite for election-related cases. Oh, we already know that. There's something else that they're going to have to be dealing with, because I'd imagine this is probably going to get kicked up to them, and based on their history, I'm not too sure, because guess what? We got our first instance of forced vaccinations. This is about as close as I'm willing, at least right now. Even though, if you guys watch the update video, which I'm going to be taking down because it's kind of irrelevant at this point, the one strike that I had on my channel, the one that was being reported as my first strike, that wasn't the first, it's fucking stupid. A one from back at the end of December. That one got its appeal heard and accepted, because imagine that, just reporting on more relapses and worse life conditions up here in Canada isn't in any way kind of circumventional to the YouTube's nebulous rules. But as for reporting any specific numbers or any kind of specific information, because there's one story out there that I would really like to talk about that kind of involves, I'll give you an analogy. How about this? I was thinking about it as well. You remember at the end of How the Grinch Stole Christmas? Just follow me. I know we're right in the middle of summer. How the Grinch, he had to hold on to the sled before all the toys went down to Whoville, and they would have been smashed after he stole everything from the city. But what would have happened if he was on top of Mount Crumpet? If something didn't grow 3 sizes that day, maybe it wasn't just a spontaneous burst of selflessness or maybe an influx of Christmas spirit. Maybe it could have been he received something unexpected in an injection form. I'll allow you to connect the two, because I'm not going to go anywhere near that, at least for the time being, even though I've seen other people report on it. But that doesn't stop YouTube from just randomly striking down channels. But who knows? I was nice to Texas, just with an offhand compliment, and then got my channel taken down for a week. So who knows? Now we're going to go talk about Texas, because this is law for the time being until I think it's the 10th Circuit Court of Appeals would have to hear this one before it would hit the Supreme Court. But you would pray somebody would overturn this, but who knows? Hospital employees must get the jab or find a new job, judge rules as he slams contention that vaccines are experimental and dangerous. Remember, that's his opinion, not mine. I'm not allowed to have an opinion. A federal judge threw out a lawsuit filed by employees of a Houston hospital system over a requirement that all of its staff be vaccinated against COVID-19. The Houston Methodist Hospital System suspended 178 employees without pay last week over their refusal to get vaccinated. Of them, 117 sued to seek said ruling be overturned and the requirement of over their suspension and threatened termination. In a scathing ruling Saturday, of course it is, District Judge Lynn Hughes of Houston deemed lead plaintiff Jennifer Bridges' contention that the vaccines are... Why did you have to phrase it like that, first and foremost, okay? It should be one of those things. The government or your employers cannot hold you down and put something into your body. That should have been the basis of your case, not that things are experimental and dangerous. If you would have phrased it better, you might have got this heard, but instead this judge shouldn't be a cunt. He also found that her liking the vaccination requirements to the Nazi-focused medical experimentation... Oh my god, this fucking bitch is the boomeriest boomer who ever boomered. Requirement to Nazis-focused medical experimentation on concentration camp captives during the Holocaust to be reprehensible. I don't really care. I just think that it's a bad analogy. Take a look at my John Moody video if you want a little bit better of a comparison between Joseph Goebbels and his experiments, or just put on the island of Dr. Moreau. That should satisfy any itch you have. Hughes also ruled that making vaccinations a condition of employment was not coercion. Oh, it certainly is, though. As Bridge contended, get the jab or you can't work here, or you can't remain employed here. I don't know. That sounds like coercion to me. That sounds like an ultimatum. That sounds like a shifting from when you were initially hired. Something where there's zero negotiation ground. It's not like you're going to get, what, a quarter of it? Like, how can you contend that? Methodist is trying to do their business of saving lives without giving them the COVID-19 virus. Hughes wrote in the 5-page decision, it is a choice made to keep staff, patients, and their families safer. And that's always what this comes down to. It's not about freedom. It's not about respecting any of the constitutional values. Oh, no. It's about keeping these hypothetical people safe. It doesn't really check out, at least not with my values. Or the ones, enshrined in writing by certain founding fathers. I don't know. Bridges can freely choose to accept or refuse a COVID-19 vaccine. However, if she refuses, she will simply need to work somewhere else. Oh, simply, because that's how that works. Judge, you have to sit on your gavel every morning. Otherwise, you can simply work somewhere else. Why would you want to do that? Don't know. Doesn't matter, though. It'll keep more people safe. If a worker refuses an assignment, changed office, earlier start time, none of these are comparable whatsoever, or other directive, he may be properly fired. Those are all negotiable. Getting the jab is not. Every employment includes limits on the worker's behavior in exchange for remuneration. That is all part of the bargain. Yeah, well, not when they arbitrarily change the terms and conditions, but we could all see this decision coming. Oh man, this guy's just old as dust, and he probably doesn't want anybody unvaccinated in his courtroom. That's why he dismissed this case. So yeah, I completely understand the people who are filing this lawsuit and their concerns and the ramifications of this dismissed lawsuit on, well, the population as a whole, really. It's just going to take an appellate court or maybe even the Supreme Court to come down and side with their senses. And this is going to be the first of many lawsuits, because this is going to be one of the big fights of the summer for sure. As things start to open up more and more, as many people return to their jobs, their furloughed positions, or maybe even apply for another spot that has become opened because the economy is booming, I've been told. And if you have to get the poke, or if you've been employed, and then in order to come back, you're going to have to get the jab, there's going to be lawsuits everywhere. And somebody's got to side with the people. At least you hope so. Otherwise, the future's looking awfully fucking grim. Sorry to end on a downer, but hey, sometimes it happens, right? And with that said, guys, I've been Don Consuelo. I want you guys to follow your gut and get after it. Catch you later, everyone.